Welcome to the Pathfinder Legacy Podcast, where we help farmers, ranchers, and business owners create a seamless transition plan for the future. From retirement to ownership transfer, we protect what you've built and guide you every step of the way.
Hello, all. Welcome back to the Pathfinder Legacy Podcast, where we talk about real-life stories, strategies, and solutions to help farm families protect what they've built and pass it on to the next generation. I'm your host, Heidi Olson. Today, we're diving into a topic that a lot of families talk about but don't always understand: how to sell the farm to the next generation without losing control or jeopardizing your retirement. One of the most common tools we use to do that is a buy-sell agreement or a contract for deed, both of which allow a founder or landowner to gradually transfer ownership to a successor over time. But here's the catch. These tools can either make a transition smooth and successful or cause major legal and tax headaches if they're done wrong. And the difference often comes down to how the agreement is structured and whether or not you had the property properly appraised before you signed on the dotted line. To help us unpack all of this, I'm joined today by attorney Brittany Foust of Neff Law. She spends most of her days guiding families through farm transitions, drafting contracts, and protecting landowners and successors on both sides of the deal. Brittany, thanks so much for being here today. Why don't you tell our listeners a little bit more about your background and a little bit more about your practice?
Thank you for having me. I am from the Northwest North Dakota area. My family farms still to this day. I had to call my dad and ask to make sure I had it right. He's a fifth generation or a fourth generation farmer, and my brother is a fifth generation farmer. So the farm has been in the family for around 100 years. So I come from a farming background. I am not a farmer. My husband is not a farmer. But now in my legal practice, I have so many farming clients that are probably around my parents' age, and they are now looking at how do we get the farm to the next generation? How do we protect the land? And it often looks different for every family. It is not a one size fits all. So you get to be kind of creative depending on what people are wanting and needing. But yeah, a lot of my practice is dealing with estate planning. Farm succession is in with that. Probate administration. So after someone passes away, and passing land or minerals after someone has passed on. And I do a lot of real estate work, contracts, drafting of purchase agreements, deeds, title work, that kind of thing.
Okay. All right. Well, very good. Well, Brittany, you and I have worked together when I was in the trust world yet. You and I worked together with a couple different clients and so forth, and got to know each other. And we've done some presentations together as well, and really had a nice balance from your experience and my experience, and have just bounced ideas off of each other and with both of our farm backgrounds. And so you're seeing that your parents are, approximately, are they in their 70s?
They are just getting to their 70s.
Okay, so just getting to their 70s. And we're seeing that we're getting to a huge transfer of assets coming in the next couple of years. And you and I have talked about this before, is what's going to happen with all of these farms and ranches and all this property that's out there if the current owners aren't doing their due diligence and planning ahead. And where are we going to be with this huge wealth transfer, if you will? And I see this more so because this is, fifth generation. You're fifth generation. Our daughters are fifth generation, and we want, we don't have as many generations in this part of the nation as they do in the South and so forth, but still to keep that going and keep that legacy. And what's the easiest or the best way to do it other than just starting where you're at right now and making a plan?
Right. Oh. Yeah. And that's it. Just, clients come in and they want an answer. What's going to work best? And it's not as easy as that. You might have seen that in your trust practice as well. A potential client comes in and they want you to have the answer. And there's a lot of different factors that come into play. How many children are there? How many are farming? Are any of them farming? There are different considerations in there. And a lot of times the fair doesn't always mean equal. Conversation comes in. And And then it comes to if we have to sell it, to be more fair to other siblings, for instance, what is the best way to do that? And I mean, that comes down to finances a lot of times. And I've always advised clients that if you're going to sell, make sure that both sides, mom and dad or grandma and grandpa, whoever, landowner is and who is buying, are talking to their respective accountants, CPAs, for their tax burdens and tax consequences that they might be looking at for things that they're wanting to do. And also having a legal advisor, potentially even a financial advisor involved as well.
Right, for sure. Because there's so many different aspects that you need to think about. And you have to have all of your advisors in your toolbox to be able to build the best plan for what you're wanting to accomplish. So one of those tools or things that, let's say they're trying to sell the land now, and the best way to do it, they've talked to their accountant and they said, okay, let's do either a buy-sell agreement or a contract for deed. So first, can you tell us what the difference is between those two agreements?
Yeah. So a buy-sell agreement is also going to be called a purchase agreement. So if people are trying to figure out what exactly that is, they may have heard it called a purchase agreement or vice versa. That is going to be most common in a traditional financing, meaning through a financial institution, a bank or a credit union, or a straight cash transaction. You can have a buyer getting the seller being the lender and using a promissory note and a mortgage with a purchase agreement. It's not as common, I would, in my practice at least, to have that, but you can do that with a purchase agreement. And that is going to be a transfer of the ownership at closing. So when you sign those documents, the buyer gives money and the seller gives a deed. And then it's secured by usually a mortgage unless it's an outright cash sale.
Okay. All right. Well, that sounds, using that example, it's just very similar to going to your bank. But it could be, you could have your family member could be the banker too. If
Yes. It's, like I said, it's not as common. You're going to see more of a mortgage usually with, a traditional financial institution, a bank or credit union or something like that.
Okay.
And with those, you're going to, especially if you are going through a bank, there are these due diligence requirements that the bank has specific for them to even lend the money. And it's usually over and above just an appraisal. There's other things that the bank might require to be done before they will agree to lend the money. And then, of course, if you're with a bank, the interest rate is subject to whatever the bank's interest rate is. And then, of course, the buyer's credit score and what they would be able to qualify for.
Right.
The underwriting side of that.
Yep, all the underwriting requirements. And it can be expensive. So depending on the amount of the loan, you could have origination fees, you could have closing fees possibly with that, in addition to all of their requirements. And if they are keeping the loan in-house or if they're going to take it out of and maybe sell a portion of that loan off as a participant. In the banking world, we kind of talk in those terms, but, for those that might be using some of the first-time homebuyer programs or the first-time farmer programs, you could possibly be doing something through Farm Service Agency with some lower interest loans and they take a portion of it. But your hands are tied because they're doing all of their underwriting items that they require. If I'm selling this land to you and I'm selling it at the current market value, then I'm going to have to pay capital gains taxes on that from whatever my price was when I first received ownership of it.
Correct. And in addition to income tax.
Correct. Okay. Yep. Income tax on the interest.
Well,
not on the...
On a purchase agreement, it's you're getting 100% of that money up front. So then and that can be, it really depends on circumstances. For some people, it makes sense for whatever they are trying to do or need to do. Maybe they're looking at doing some sort of 1031 exchange, 1033 exchange. They might have other plans. This is where it becomes very important to talk with accountants, financial advisors, and a legal team or a legal professional to see what makes sense for you, because there might be reasons that a purchase agreement with 100% of that income coming in at once makes more sense for you. It might even be age or health considerations.
Right.
But yes, you will be looking at capital gain, usually,
capital gains tax,
when we're looking at land, and then the regular income tax, which could, depending on how much land you have and what the fair market value is of that land, you could be looking at a new tax bracket.
Right. Yep. Could really bump you up. Yep. For sure. Yeah. Okay. So let's move to, so we kind of have an idea of what a buy, sell, or purchase contract would look like. But now, how about a contract for deed? What are some of the basics on a contract for deed? Their characteristics.
Contract for deed, the seller is essentially financing the sale in that you are taking money over time for the buyer's interest. So the seller keeps an equity interest in the land meaning you get the right of the income from the buyer on that land, not the income to the crops coming off of it, but the income from that sale over time. And usually, you can see a 5-year contract, 10-year contract, 15-year contract. My experience, 15 years is usually the most common with families. And I think that is largely due to the age that they are entered into for both parties. If you have a 40-year-old that's buying the land, they're like, I want to be done buying this by the time I'm 55. Or, there's that time frame usually plays into the age of the parties involved, in my experience, or how much they can afford. The buyer has a legal interest in the property, but it doesn't what's called fully vest until all payments have been made on that contract. So they don't have 100% right to that land in the ability to go to a bank and finance on that land for other purposes, for instance. But you can sometimes, do things like put buildings or grain bins, that kind of thing, because you'll have enough interest in the land with the contract for deed, but it's not a full ownership until that contract for deed is done.
Until it's paid off.
Until it's paid off.
So when you do a contract for deed, that is recorded in the courthouse. So if someone else is wanting to put a lien or something against that property, they can't do it because they will see that there is already a contract for deed on the property. Is that
when you say a lien? What do you mean? Like
if someone was going, like a second mortgage or something, if they wanted, could they do that with a contract for deed?
It should be recorded. I'm sure that there have been private contracts for deed that are done that were not recorded, either because people didn't know that it needed to be recorded. If it's not a record, no one's going to know about it. So it is important that it is recorded so that you can prevent these other potential lien holders from going after the land and you not having priority, you as buyer or seller, depending on who the lien is against, right? Having priority.
Okay. Yep. So if I was to take it, like I've paid down 50% on it already and I'm built that equity in there, just so for our listeners, so they know you can't take that to your bank, and your banker should tell you as well. They're not going to do a second mortgage or use that equity that you have in there because it's a contract for deed and the buyer or the sellers take full priority on that.
Correct. Yeah, because the seller has basically foreclosure rights. If the buyer, being you, breach a part of the contract, which typically would be payment, you're missing the payments, but it could be a substantial breach by you can put other things in the contract that they weren't allowed to do. And if they do it, it is a default and a substantial breach of the contract, meaning the buyer then, or the seller rather, can get the land back because they violated certain terms. That could be the buyer allowed a lien to go on the property. That can be a reason for sellers to get the land back. So when it's a foreclosure like that, which is essentially what it would be if there is a breach on the buyer's side, the seller generally has to go through a foreclosure process unless the buyer can or agrees to quit claim, sign a deed back to the buyer for 100% of their interest. But then if you have lien holders on there, then you have to address the lien holders as well, which it can get a little more involved if that's the case. But you put provisions in a contract to protect the land. And that, so that there are no, part of that is no liens from either party are allowed or if a breach of the contract. We had talked about earlier that, if you allow certain mining rights or something that go with, and there's a breach due to the use of the land, it's a default fallback for the other party, the non-breaching party, to be made whole again, so that basically the land goes back to them.
Right. Okay.
And they don't usually they do not repay the money that has gone toward that contract. So if you paid 50% and you breach after that, you're out of that money and you're out the land.
Yep. And then it goes back to square one. So like, for example, we talked a little bit earlier, gravel. So using that as an example, if someone is going to come in and mine some sort of gravel or something. And okay, so first I'm going to take a step back. Is gravel included part of the surface? Just so for our listeners, so they know, or is it part of the minerals that can be mined?
In North Dakota, gravel is a surface mineral. So if it is not specifically excluded from the sale, it will go with the surface. Okay. Which is same with subsurface minerals. If you don't specify that subsurface minerals are not part of the sale, they will go with the land as well. But surface minerals are sand, gravel, clay, scoria. The Century Code has a list of them.
Okay.
But gravel is a surface mineral. Generally stays with the surface owner.
Mm-hmm. Generally it stays with the surface owner unless someone has indicated that they want to reserve that. Then that would have to be a specific clause in the agreement. Yeah. So if you reserve that as a seller and it would basically be a breach of contract if that buyer is using that and selling it for their own. So, that could be a clause that you would put in the contract.
Yes.
Have you seen in your practice, where sellers have reserved specific rights in a contract for deed?
Other than subsurface minerals, I have not had a lot of reservation of rights. There's been that they cannot sell to a third party, at least during the pendency of the contract. It's not assignable without written agreement of the buyer. That's pretty common. So that would be allowing the buyer to maintain some control. If you're selling to you and I'm buying from you, and I realize I'm not going to be able to continue on with these payments. It's not going to work for me financially, but my brother can. So I'm going to just assign my interest to my brother. If we had it in the contract that I cannot just assign my buyer's rights to someone else without you agreeing to it, I wouldn't. It would be a breach of the contract if I tried to do that. But if you were comfortable with that, you could agree to someone else taking over that contract. But it gives the seller control over who is actually purchasing that land.
Right.
Which is important for farm succession.
Yep, for sure. So, if they have a worst case scenario, someone's health fails or case of a death, can someone else take over that contract on their behalf or maybe they don't have all their faculties anymore and they can no longer operate a business. So have you seen anything that you could think of that you've seen that would be so out of the ordinary in your practice that someone has asked? We've seen, we see a lot of different things people put in trust agreements on things that they want to control. Have you seen a lot of control issues with the seller wanting to make sure that there's specific requirements met for buyers?
I haven't, which is actually kind of surprising when I think about it. However, I do think most of the contract for deeds and family sales that I have been a part of, there's been extensive conversations and also a partnership between the buyer and the seller for a period of years, that there's more of a comfort level in the buyer actually performing their side of the contract and utilizing the land in a way that the seller is comfortable with. So that hasn't come up in my practice, but I could see that coming up as, a younger generation farmer not farming the way grandpa or, dad or whoever thinks that they should be farming, or utilizing the land in certain ways because technologies have changed and the farming practices have changed so much through the years. So over time, 15 years. So if dad retires now and the contract is a 15-year contract, in 10 years, they might think, what is my son doing out there?
Right.
So I caution, I think it's a contract, and if it's agreed by both parties, you can put it in there. In contracts, you see in like a farmer's like manner, or you'll see some language like that, which I do think encompasses practices that, the technology changes and the changes in the way farming works and runs over time. So it's not trying to, pigeonhole you. But if you have that in the contract and the seller doesn't like what you're doing, I think then that could be a potential issue for the buyer. And I think ultimately probably a judge would probably have to decide on whether or not it's a real breach of the contract. If it came down to just farming practices differences. Now, if you are letting the farmland go to waste, that would be different. Because a lot of times in a contract, during the pendency of that contract, you are utilizing the land so as not to waste it, or to damage the land in a way that would diminish the value, significantly diminish the value of the land.
Right.
And that's different than just differences of opinion on farming practices.
Okay. Yep. And really then it comes down to taking the seller, their interpretation of, are you damaging to the land? Or their interpretation is, are you using it in good farmer-like practices and managing the land how it should be so it still is not devaluing the property?
Right.
And so really knowing who your buyer is and having an established relationship with them. And you can't always cover every worst case scenario. I always tell my clients, okay, you think about plan A, and then you probably have plan B, C, and D, because if something should happen, and God forbid, we all think that our timeline is extended to infinity and beyond, but we just don't know what's going to happen from one day to the next. So having those backup plans, if you will, that if something happens and husband passes away, he was a farmer, will the wife continue to stay there and farm? Or maybe there are young adult children, that could step into it. And then possibly they could take over the contract for deed payments. So
one thing that I wanted to touch on with contract for deeds specifically, something that I have a lot of family members wanting to do is a 0% contract, at least for a number of years, maybe at the beginning of the contract for deed, first 5 years or something, or a low interest rate, because in their words, it's, well, why won't they just go to a bank then? And the banks have a higher interest rate. It's my son. I want to give him a break. And that is something, although you can do it, you have to work with your CPA, because what would end up happening in the cases that I've worked on, they have essentially gifted the interest rate that the IRS has interest rates that they publish monthly.
Mm-hmm.
And you use that interest rate, for the month that the contract went into effect and the year. And that is a gift. How much that interest would have been is a gift to the buyer. And so if it's over the gift threshold, which like right now is $19,000 per year per person.
Yep.
If it's over that, you'd have to do a gift tax return for that amount.
Mm-hmm.
So it's not that I've had some people say, well, you just can't do that. It's not that you can't do it, but in the eyes of the IRS, you can't do it. So that really is a gift. You're gifting, the 4.6% interest that you should have received per the IRS publication for the interest rate or whatever that might be. It's important to know those things because the gift tax return itself right now isn't a huge deal for a lot of people because of the estate tax threshold being as high as it is.
Mm-hmm.
But if that were to fall, because I think it's 17 million per person, roughly 16.99, and I might have that number wrong, but it's very high per person, roughly 28 million for a couple. So right now we're not seeing a lot of hesitation with doing some of that gifting because it's not really affecting what they have in their net worth for their estate at the time of death. But if that were to fall, that's going to change. So if a new administration comes in and they drop that estate tax threshold significantly, which has been talked about in several administrations, that's a big consideration. That could change how you want to approach a contract for deed. These are things that not every attorney is going to know. Not every financial advisor is going to know. And unless the individuals are keeping up on tax code changes, they're not going to know. Having a CPA involved is very, very important so that you don't unintentionally cause some tax ramifications for yourself or for your child, and not just in the event you get audited. There's other ramifications that can happen if you're doing things improperly and you get audited. If you're doing these things wrong and you end up with a huge tax bill, if you don't have cash, what are you going to do? And you now have already sold your land. So it's just something to be aware of. It's not something you can just shake hands on like we want to, And then the same thing with the appraisal. You have to know what the net value, the market value is for the land. And if you want to go lower than that, okay, but here's what it's going to do for your taxes. Here's what we're going to have to do. If it's worth $2 million and you want to sell it for 1.5, okay, then that's a $500,000 gift today to the buyer. And here's what that will do with your taxes,
All right, friends, that's where we'll wrap up part 1 of my conversation with attorney Brittany Foust. I don't know about you, but I feel like we could have kept going for another hour. Next week, we'll pick right back up, digging into those tricky what ifs, like the necessity for an appraisal, for selling your land, fairness to family, where fair isn't always equal, and the importance of title work and keeping your land and legacy secure. Listen in for practical advice on how families can structure land sales the right way, and we're just getting started. In the meantime, you can reach Brittany on her website at nefflawnd.com. That's NEFFLAWND.com. Or by phone at 701-577-2000. I will have her contact information in the show notes below. So grab your coffee. Join me again next week, and we'll get into the rest of this important conversation about protecting your land, your plan, and your peace of mind. And you know how I close things out. At the end of the day, this isn't just about selling land. It's about setting the next generation up to succeed. Until next time, I'll see you between the ditches.
Thanks for listening to the Pathfinder Legacy Podcast, where your future is our focus. Be sure to subscribe, follow us on social media, and visit us at pathfinderlegacy.com to start building your transition plan today.